Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 148 proceedings. In this case, the issue before the Honorable Punjab and Haryana High Court was that if the notice under section 148 is issued to the assessee on a wrong presumption that the assessee has not replied to the notice issued to the assessee under section 133 subsection 6 and the notice has not been issued by the jurisdictional assessing officer and by the assistant commissioner, so whether in that case on these grounds the notice under section 148 is liable to be quashed. This issue has been taken up by the court in the case of Vishal Garg versus Assistant Commissioner of Income Tax and others, and this case is reported in 476 ITR at page number 178 on 19th September 2024. The facts of the case are very interesting in the present case. First of all, a query notice under section 133 subsection 6 was issued to the assessee by the jurisdictional assessing officer seeking contractual receipts and fees details. The assessee duly replied to this notice that the assessee has the commission income and the assessee has already included that commission income into his return of income for the assessment year 21-22. But all of a sudden, on 31st March 2024, the Assistant Commissioner of Income Tax, which was not the assessee's jurisdictional assessing officer, issued the notice to the assessee under section 148, and the reasons which were provided to the assessee for reopening the case of the assessee was that the assessee has not incorporated the commission income into the returned income and the assessee has not replied to the notice issued to the assessee under section 133 subsection 6. So from the issue of the notice, it was very clear that the assessing officer has not considered the reply of the assessee under section 133 subsection 6. So the assessee challenged this notice through a writ petition in the court, and when the court heard the matter, the court said that once it is established that the assessee has filed the reply and the assessing officer issued the notice on a wrong presumption that the assessee has not filed the reply under section 133 subsection 6, then it would be unjust to allow the department to make the assessee participate in the assessment proceedings. The court said that in the present case for the assessment year 21-22, sales commission has been incorporated into the income of the assessee by the assessee, and the assessee has elaborately said that this commission has been received to the assessee from an entity UFO which has been taken into the income of the assessee. So in the present case, the court said that the notice has been issued on the wrong presumption, and also the court quashed the notice on the ground that the notice has not been issued to the assessee by the jurisdictional assessing officer. In the present case, the notice under section 133 subsection 6 has been issued by the jurisdictional assessing officer, but the notice under section 148 was not issued by the jurisdictional assessing officer. So on both grounds, first ground, issue of notice on the wrong assumption, and the second ground, issue of notice by the non-jurisdictional assessing officer, the court quashed the assessment proceedings. Friends, from the conclusion of this case, it is very apparent that whenever we receive any notice, we should comply with the notices, because it has been seen that whatever the assessee is replying to the revenue is not taking the heed to consider those replies. So at least the assessee can take the benefits in the jurisdictional grounds or technical grounds that the notices has been issued on the wrong assumptions and wrong facts. At the end of this video, once again I am repeating the name of the case. The name of the case is Vishal Garg versus Assistant Commissioner of Income Tax and others, and this issue has been reported in 476 ITR at page number 178, and the date of the judgment is 19th September 2024. Friends, this case is very important because we should try to correlate the reasons with the facts of the case, because once the facts are wrong in the reasons, then the whole notice is liable to be quashed.